Good morning, Ms. Hofmeyer. Good morning, everybody.
Good morning, Chair.
Are we ready?
We are indeed, Chair.
Yes. I see one of the lights that is usually on is not on. Is that deliberate?
It was, Chair, because my ability to look at that screen is somewhat impeded if that light is on. But if it's an issue for you, Chair, we can navigate, put it back on, and then I'll make certain that I only ever look at that screen.
No, that's fine. But
Hello?
Ms. Myeni, can you hear us?
Good morning. Yes, I can hear you.
Good morning to you.
I think I can hear you clearly. Yes.
Okay, all right. We can hear you too. Thank you. No, if where that light is located is going to be a problem for you, maybe they can see whether they can move it to a place where it won't be a problem for you. Maybe if I just wanted to light somewhere.
Yes. No,
there.
Chair, can I say, if it is useful to have it, I will just make sure I use that screen. So then I just won't look that way. It won't be an issue.
No. I want you to look where you are comfortable to look. They have just moved it a bit now. How is that?
Oh, that's better. Much better.
That better.
Thank you.
Okay, all right. Okay. Thank you.
Thank you, Chair. Chair, today we receive the evidence of Ms. Duduzile Myeni. She is legally represented, and so if we could take a moment for her legal representatives to place themselves on record.
Yes. Okay, that's why I think he will come over. You could do it from where you are, Mr. Masubu, if that's fine, because it will save us some time.
I don't know how to stand talking to the Chief Justice. I have to sit and speak to you. But now that you've permitted me to...
No, I'm permitting you. Yes.
Yes, together with Mr. Buthelezi, we appear for Ms. Myeni.
Yes.
And Chair, you will notice that we're not exactly where she is. We will be giving her advice.
Yes.
So if we don't intend to interrupt you, or to interrupt the flow of the evidence, but if there's something that really crops up, we will politely indicate that we need to speak, and obviously if she needs to speak to us, she should be free to indicate as well.
Yes, okay.
And with your leave, we can perhaps phone her and hear what she says.
No, that's all right. Well, you talk about interrupting the proceedings, Mr. Masugu. I can say that if your last appearance here is anything to go by, these proceedings will be very smooth. I think you only interrupt when it's really necessary.
Yes.
You don't just interrupt. So I think if your last appearance is anything to go by, that's when you appeared for Mr. Van Rooyen, I think. Everything went very, very smoothly. So
I'm glad to say that.
I appreciate that very much.
Thank you.
Yeah. Okay, all right. I don't see Ms. Myeni now, so there may have been some technical problem that has arisen.
Chair,
just one last thing. I'm not here from tomorrow and
on Friday,
Mr. Buthelezi will
be here. No, that's fine.
Thank you.
Chair, I've been informed that there's been a connection problem. It seems that Ms. Myeni has lost bandwidth. So we're going to need to have to establish what the problem is and endeavor to reconnect.
Okay, I think let me adjourn then, and hopefully it won't take long. And then hopefully when we start, everything will be smooth.
Yes, thank you.
We adjourn.
I can hear you.
Ms. Myeni, we have asked your legal representative, Mr. Baloyi, who's assisting you there, to please try and connect you to a laptop, because the mobile phone is going to continue giving us challenges, because you just got cut and we will have challenges moving forward. So a laptop might be a better option currently. So and your internet connection is very unstable, as we can see it, but maybe on a laptop it will be better. So Mr. Baloyi is trying to assist in connecting you to a laptop. We have just adjourned so that can be able to connect on a laptop. Please unmute.
Okay, it looks like the technical problem has been sorted out.
Indeed, Chair.
Okay,
As I understand it, Ms. Myeni has now been provided with a laptop by her legal team, and we hope that that will greatly assist today's proceedings. So we're indebted. Thank you for making those arrangements.
yes, well, her picture is also much more clearer now than
Indeed.
it was before.
Indeed.
Yes, Ms. Myeni, can you hear me?
Yes, Chairperson, I can hear you.
Okay, thank you. We can hear you well as well. Thank you. Okay, let's start. Let's do the oath. Please administer the oath or affirmation. Ms. Myeni, you might have to come in at some stage when your health situation permits to confirm everything under oath in the commission, but for now we'll do the oath via video link. Okay, please go ahead.
Please state your full names for the record.
Duduzile Myeni.
Do you have any objections into taking the prescribed affirmation?
I do not have any objection.
Do you solemnly affirm that the evidence you will give shall be the truth, the whole truth, and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I solely affirm.
Thank you very much. It seems that there is a delay. Is it supposed to be like that?
Chair, as I understand it, it's a product of the relative quality of Ms. Myeni's bandwidth. So what we've been asked to do today is just try and ensure that we work with the delay. So we ask questions and we anticipate that there'll be a delay in the relay for her answer, and then we also wait after the answer to ask the next question. I understand that's going to be the best way to facilitate the proceedings.
Okay, no, that's fine. Okay, you may proceed then.
Thank you, Chair. Ms. Myeni, I'd just like to ask a few questions about your setup today, because it's important that we just get certain things on record. Can you confirm that you are alone in the room that you are currently present in?
I'm in self-isolation, ma'am. I am being assisted by my representative from the Mabuza attorneys. There is always a day helper in the place I stay. But what happened to me was the notification about COVID-19 exposure happened while the day helper was in the house. So she is here with me and the representative from Mabuza attorneys.
Thank you.
That is why today I have not been able to come before the commission because at the moment I'm just observing progress on my side. I'm also ensuring that I'm taking necessary precautions because I haven't felt anything as yet, but the other person is confirmed to be positive.
Thank you, Ms. Myeni. We really appreciate the efforts that you're taking to be available today. Then the other thing I need to just confirm with you is that you won't receive any messages during the evidence that you give, and if you do receive messages or communications, you will alert the chairperson to that fact.
I apologize, Chair.
Sorry, 1 second.
I apologize, Chair. I cannot understand that she would be asked to make that condition, because we're here. we communicate with her on SMS. I don't understand why she would be required to tell you what our communication with her is. If the idea is that we shouldn't communicate with her unless we tell you what we're communicating with her, I don't understand that condition.
What do you want to say, Ms. Hofmeyr?
Chair, I was just wanting to explain the background to the question. You see, if there's a witness present in the room with us, they don't communicate with their lawyers while they're in the room. If there's a need for the lawyers to communicate with the witness, there can be a request for an adjournment or any such thing. The question was not intended to limit in any way those types of communications. But as we have done with at least one other previous witness whom we've addressed in evidence on Zoom, we always ask these questions because there's a level at which, because of the remoteness, we need an undertaking from the witness that during her evidence she won't be receiving messages from anyone else, because that would diminish the quality of her evidence if she was receiving communications during it. So that's the basis for the question.
Mr. Masugu?
No, I appreciate the answer, but,
Yes.
but I do want to make it clear that as legal representatives, we're entitled to interject when we need to speak to her, or she's entitled to also raise the fact that she would like to consult with us, and that we shouldn't be restricted as far as that is concerned.
Yes, no, I think based on what both of you have said, I think Ms. Hofmeyr's concern is that there should be no assistance to the witness in regard to the evidence. Obviously, there would be no such assistance from the legal team side. But maybe the arrangement not be that when you have a need to talk to her, we can adjourn, and then you can talk to her. Would that be fine?
That will be fine, and I can assure you, Chair, it won't be a
No.
frequent issue.
No,
So-
that I accept without
Yes.
any problems. Yeah,
Thanks,
yeah.
Chair.
Okay, all right, okay. Thank you. Ms. Hofmeyr?
Thank you.
I think Ms. Myeni was in the process of, or was about to respond when Mr. Masugu wanted to say something. Do you want to remind her of your question in case she has forgotten?
Yes, it was just to give her confirmation that she won't receive communications while she is giving evidence, and if she does, that she will simply alert us to that fact. Because we've catered for communications between Ms. Myeni and her lawyers, which we'll manage in the way that we've discussed.
That is noted, and thank you for that. But Chair, I must also thank you very much for allowing me to appear before you through this process. And there is an appreciation on my side that I had to ensure that I appear as per the subpoena that I received, and I thank you for allowing me to appear through the Zoom. Let me assure you, Chairperson, that my phone is off.
Yeah.
So I don't
Yes.
count you receiving any messages from anyone. And I think
Yes.
the representative from the office of the Mabuza attorney is not here where I'm sitting.
Yes.
Also, I think to ensure that he is also safe
Yes.
in case I
Yeah.
am
Positive.
positive.
Yes. No, thank you very much, Ms. Myeni. Thank you for making all the efforts you have made to ensure that the fact that you may have been exposed to somebody who has tested positive did not result in the commission not sitting. So I understood your request and had no hesitation in granting the request that you give your evidence via video link. So that is appreciated.
Thank you, Chair.
Thank you.
Thank you. And then, Ms. Myeni, the one other thing I'd like to do is just from a logistics point of view, confirm that you have the files that were delivered for you this morning once we were notified yesterday about your situation. Do you have those files available to you?
Yes, I do.
What we're going to deal with mainly today is a file that on the spine of it, there will be two of them marked DD34, and they bear your name. So I suggest that you have those readily available to you, and then I will ask the chair to enter that into the record as Exhibit DD34.
In front of me.
I've got Ms. Hofmeyer file written DD34A. It's written Exhibit DD34A. I guess it should be bundle DD34A.
Correct, Chair.
Yes. Let's start with that, just so that we will speak from the same page. On the spine of that file, I'm changing exhibit to bundle. Bundle DD34A. So that's, when we say bundle DD34A, that's the file we'll be referring to. Maybe we should, for the sake of completeness, do the other one as well.
Yes, indeed.
Will it be 34B?
Correct, Chair.
Okay. So the other file, which is written Exhibit DD34B, on the spine, will now be bundle DD34B. Okay.
Thank you, Chair. And then
right,
when we
then.
come to specific documents within it, as we've been doing, we'll identify them as DD34.1,
Yes.
2, 3, or
Yes.
as we follow the index.
Yeah, they will be exhibits DD34A point whatever.
Correct.
DD34B point whatever.
Thank you, Chair. We're indebted.
All right.
So then I would like to start, if we can, in bundle DD34A, because Ms. Myeni, that commences with the affidavit that you provided to the Commission in response to the Chairperson's directive requiring you to provide an affidavit. When I direct you to page numbers, they are going to be the page numbers in the top right-hand corner of a page. So could you please go to page 1, and Chair, that will be Exhibit DD34-1. It's the affidavit of Ms. Myeni in response to your 10-6 directive.
Yes, after you've got her to make the necessary confirmations, you'll ask me to admit it as an
Indeed.
exhibit. Okay.
Ms. Myeni, if you'll then, have you got page number 1 in front of you?
001. It's
Correct.
DD34 DCM 001.
Indeed. Thank you, Ms. Myeni. I'll tend to leave off the full DD34 DCM. I'll just identify the number of the page when we go through today's proceedings. But do you have that in front of you? If you'll say yes, thank you.
What she will do, Ms. Myeni, is that, for example, where your affidavit starts, which is written 002, she won't even say 00, she'll just say page 2. Where it says 003, she'll just page 3. So whenever she'll mention the number without the 00s before. You understand?
Thank you, Chairperson. I do understand.
Okay, all right.
And then, Ms. Myeni, if you could turn to page 11, and could you confirm whether that is your signature on that page?
Yes, it is my signature.
And then can you confirm that this is the affidavit that you deposed to and that its contents are true and correct?
Yes, it is my affidavit, and the contents are correct.
Thank you, Chair. If we could then enter it as Exhibit DD 34.1.
Taking off the A now.
Oh, yes, apologies, Chair. Yes, because on the numbering, then there's no A. But let's do DD.
Let's keep the A.
DD 34A.1.
Point one, yeah.
Thank you, Chair.
The affidavit of Ms. Duduzile Myeni, starting at page 2, is admitted as Exhibit DD 34A.1.
Thank you, Chair. Now, Ms. Myeni, in this affidavit that you provided in response to the Chair's directive, you indicated that you were going to invoke your right to silence at today's proceedings. And you also made certain claims regarding pending appeals, etc. What I'd like to know from you to begin with is whether you are persisting in claiming on a basis of a right to silence that you do not want to answer the questions that are put to you today.
Please repeat your question.
In the affidavit that you prepared and that we're looking at the moment, in response to the Chairperson's 10.6 directive, you indicated that you intended to invoke your right to silence when you came before the Commission, and you would do so in order not to answer any of the questions put to you today. And I'm seeking clarity whether you persist in that position.
Chairperson, I came before this commission in terms of its rules. I filed the affidavit indicating that while I respect the commission and wish to assist the commission, I am in a very difficult position, because before me there is a court order directing that I be charged in this regard. I think I am anxious that I'm compelled to forgo my constitutional right not to incriminate myself. So in my affidavit, I've referred the commission to the documents relevant to the issues that were raised by the commission. I did that, Chairperson, because I highly respect this commission. I always act responsibly, and I am willing and I committed to present myself to this commission so that we deal once and for all with everything that has been said and all the false accusations and insinuations about me that have been made in my absence. But now the problem I have is that the court judgment, which I have been advised to appeal, is before the commission, and it's known, it's public, and therefore I would like to exercise my right and answer where I can and be silent where I can. Thank you, Chair.
Thank you. Yes, Ms. Hoffman.
Thank you, Chair. If I could suggest at this point that it might be appropriate to just delineate what we as the legal team of the Commission understand the legal position to be in relation to Ms. Myeni's invocation of the right to silence, but which I understand her just to have said is actually coupled with a willingness to answer some, but not all questions. And so I would just, with your leave, like to navigate that issue momentarily. It won't be a question to Ms. Myeni, it will be to address you, Chair, on the issue so that we can have direction for the way forward.
Yes, no, before we do that, I just want to say to you, Ms. Myeni, that the Commission would not seek to deliberately and intentionally infringe any of your constitutional rights, where any of the rights you wish to rely on are applicable, the Commission would seek to respect those rights. We have had occasions where some witnesses have taken more or less the same attitude you have taken. One was, I think, Mr. Vincent Smith, and I think another one was Mr. Mokhetsi, and they were represented by counsel. With regard to both of them, with the advice of their counsel, I think Mr. Mokhetsi was represented by Mr. Mpofu. In the end, I think there was only one or two questions that they refused to answer with the advice of their counsel. For the rest, they were able to answer, I think partly because they wanted to just tell their side of the story, which they might not have had a chance to tell. So we, where it's a right that is applicable, the Commission would seek to respect that right. But as I say, in the past, there have been instances where people want to use that right, but also want to be helpful to the Commission as possible. And as I say, in both cases, we ended up with a situation where, there may have been one or two or three questions that they were not comfortable to ask, and there was no issue from the Commission, but they gave all other questions. My own understanding of what you are saying is that, one, you want to assist the Commission as much as possible, but two, you would like to try and strike a balance and protect your rights in regard to certain questions. You certainly are not saying you don't want to answer any question at all. That's my understanding. So having said that, I need to say, well, maybe if Ms. Hofmeyr, you and Mr. Masugu haven't had a chance to discuss this issue, it might be better if there's a discussion between the two teams, because if there is agreement, that might make things smooth. Obviously, if there is no agreement, then if there is going to be argument, then it might be on a very narrow point or issue. So my suggestion is that maybe I should adjourn so that you have that discussion. Certainly. And then you can approach me in chambers to indicate the outcome. Is that all right?
Thank you, Chair.
Ms. Myeni, we are going to adjourn to allow Ms. Hofmeyr and your legal team to have a discussion about how we are going to proceed with a view to respecting your rights where they are applicable in these proceedings, but nevertheless being able to get as much assistance from you as possible. So they will discuss and they'll come to me in chambers and talk to me. And then when we resume, you will be told what the situation is. Okay?
Thank you, Chairperson.
Yeah,
Thank you,
thank
Chair.
you. We adjourn.
Ms. Myeni? Ms. Myeni, can you hear us? We are going to resume shortly. Can you please take your position? Tumza. Ms. Myeni? Can you hear us, Ms. Myeni? Please unmute and take your position. Thank you. Pin her there to me, pin the witness. Thank you. Ms. Myeni? Can you please take your position, Ms. Myeni? Can you take your position, Ms. Myeni? Can you hear us? Just to test quickly before we resume. Ms. Myeni, can you please take your position? We're about to resume. Thank you. Thank you so much. Thank you.
Hello? Yes,
Yes, can you hear us, ma'am?
thank you. Yes, I can hear you very well.
Thank you, ma'am.
Yes, Ms. Hoffman.
Thank you, Chair. We are ready to proceed.
I understand that the discussions between yourself and Ms. Myeni's legal team resulted in an agreement
Indeed,
on the
Chair.
way forward.
Indeed it did.
Yes, no, thank you very much. I appreciate and thank both parties for reaching an agreement on that. And I understand that Ms. Myeni has been briefed on the way forward. Yes, okay, thank you.
Thank you. Ms. Myeni, when did you become chairperson of South African Airways?
In 2013.
And,
Early 2013.
and prior to that, did you hold the position of acting chairperson?
In December 2012, indeed.
And when you were appointed, you gave an undertaking to the Department of Public Enterprises. Do you recall that?
Chairperson, matters pertaining to SAA, I would really prefer to invoke my right to silence on any matter pertaining to SAA. May I qualify why I'm saying this, Chairperson? You will recall, Mtiane, that, you will recall, Chairperson, that OUTA, the private organization that took me to court together with the Pilots Association, they opened a case, I think it was in 2017, early 2017. It was before the start of this commission, Chair. For some reason, which we did write to the commission to inquire about the documents that were being used by a private organization with the ink, the letterheads and the logos of the Commission of Inquiry. The majority of documents, in fact, almost every file from OUTA were files coming from the Commission. My legal representatives wrote a letter to inquire if the Commission or the Chairperson has given permission to use the documents, being a private organization, as evidence in the case against me. Almost every question pertaining to South African Airways was contained in those documents. Therefore, I prefer, Chairperson, with your permission, to invoke the right to be silent on the matters pertaining South African Airways. There is a standing judgment which was handed down on the 27th of May by Judge Tolmay, wherein OUTA and the Pilots Association wanted me to be declared a delinquent director for the decisions of a collective board of South African Airways, which were then put on my shoulders as one person. Therefore, Chair, may I not answer any question pertaining to South African Airways, especially those questions that OUTA as a private organization, not a state organ, that had access to the commission, to the commission's documents. With your permission, Chairperson, I would like not to answer, but I'm prepared, Chairperson, to continue question by question to say I invoke my right to silence. I think, Chairperson, that is what I would like to do. And I also want to emphasize, Chairperson, that I came before you because I have respect for you. I have respect for the Commission. I have respect for the work you are doing. I also, Chairperson, want to assure you that I am a law-abiding citizen. Therefore, I really don't want to incriminate myself and answer to questions which the judge has asked NPA to investigate, whether the judge found against me or not, but she referred all matters pertaining to collective decisions by the Board of South African Airways to be laid over me or to be given as my responsibility alone. Therefore, Chairperson, with your permission, may I invoke the right not to answer the questions? With respect, Chairperson.
Thank you, Ms. Myeni. My understanding is that both the evidence leader, Ms. Hofmeyer, and your legal team, after discussing the matter of how we would proceed with a view to striking a balance between you assisting the Commission, but the Commission also respecting those of your rights that may be applicable to these proceedings. My understanding is that they reached agreement that you would invoke your right not to incriminate yourself in regard to specific questions as opposed to seeking to invoke it to refuse to answer all questions that might relate to SAA. My understanding is that the expectation is that you can be asked questions that relate to SAA. Some of those questions, it may be that you may invoke that right, but others, it might not be applicable because they might not be incriminating. So that's my understanding, but I see Mr. Masugu is ready to indicate to me what their position is. Mr. Masugu.
Sorry, Chair, I think that understanding may be overstated.
Yes, okay.
We specifically, our agreement is that she will assert her right to questions and topics that she believes are topics or questions that might be a subject of interest by the law enforcement agencies right now. Her explanation of the SAA matter falls exactly within the agreement. She has invoked her right to silence in its totality.
Oh, okay.
We don't understand that to be outside the ambit of our agreement, as far as maybe Kate will explain, will take that. Because my understanding of what Ms. Hofmeyer said was that that doesn't stop her from asking questions about SAA. If she wants to ask questions about SAA, she can ask questions about SAA, but her response is perfect in the sense that it says about SAA, there are documents coming from this commission, which were used in the court application that has now resulted in her being a subject of investigation by a court order, which is sanctioned by a court order.
Yes.
Now, the scope of which is not known, because if you look at the order that was made by Judge Tolman, it says everything about SAA that was covered in that application must be sent must be referred to the NPA for the NPA to investigate. So I do not believe that her answer is inconsistent with the agreement.
Yes.
Because the agreement was that she would, in fact, invoke her rights, even though that does not stop the commission from asking questions that they want to ask.
Okay, no, I certainly didn't understand the agreement that way. Subject to argument, my inclination would be that she could invoke the right not to provide an answer to specific questions, but not to say, I'm not going to answer any question on any SAA issue at all. So subject to hearing argument, my inclination would be there would be questions that she could answer without incriminating herself, in respect of which she could not invoke such a right, but there would be questions where she would be entitled to invoke that right, and her right would be respected by the commission. It's a question of which questions fall under which category. So let me clarify this. Ms. Myeni, is the position that at least in terms of what you would wish, you put it as what you would prefer, in terms of what you would wish is that you not be asked questions on SAA, or if you are asked questions, you'll be allowed not to answer them. But in regard to any other matters, such as matters that might relate to ESCOM or BUSASA or any other matters that are not SAA, you don't have a problem. You can answer questions on those. Is that correct?
Perhaps for the record, Chair, I can repeat what I've said. OUTA collaborated with the Commission and got all the documents and the questions that are contained in all the letters that I received from the Commission. OUTA is a private organization, and OUTA was able to use all what is contained on the documents that I'm expected to answer today. And they relied on the information that they got with the watermark of the Commission, all their documents. It was not a hidden thing. Therefore, Chairperson, as I think I listened to Masuku, SC, and I listened to you, Chairperson, it is accurate that I would like to invoke my rights on matters pertaining to South African Airways for the reasons stated that there is a judgment before me for collective decisions that we took as the board of South African Airways. There is a judgment that was handed down that says there must be further investigation, and NPA could possibly charge me for those decisions. Therefore, I would prefer not to answer anything pertaining to South African Airways, Chair. And you are indeed correct to say I do not prefer to say anything pertaining to SAA.
Yes, but my question went further than that. It seems obvious, but I want to have clarity, to have certainty. It seems obvious that you are not seeking to invoke the same right in relation to matters that don't relate to SAA, such as maybe BUSASA and ESCOM. I just want to have certainty that that is the position.
Chairperson, the rest of the questions, we will deal them as we go. With your permission, Chairperson, we will deal with each question as we go. That has nothing to do with South African Airways. Thank you, Chair.
Okay, all right. Ms. Hofmeyer, do you want to say something?
Yes, indeed, Chair. There does seem to be misunderstanding about the agreement. So I think it's preferable just to state what our understanding of the legal position is, and then I do want to address pertinently Ms. Myeni's allegation or suggestion that there's been some sort of collaboration between the Commission and ALTA vis-à-vis her trial, because there was correspondence about it.
Yes, maybe before you do that, let me say this. Ms. Myeni, I saw in the, I think in your affidavit, a reference or a concern or complaint about the fact that ALTA used documents that it seems to have obtained from the Commission. I was hearing about that, I think, for the first time. But I don't know when they obtained the documents, and I don't know what process they would have followed. I assume they followed some process. But generally speaking, once the documents, witnesses have given evidence in the hearing, the documents become public documents. It's only before that they are not public documents. So, but once witnesses have given evidence about those documents, they become public documents. So, but I think Ms. Hofmeyer will say something about that as well.
Chair, I seem to see
yes.
my learned friend.
Mr. Buthelezi.
Thank you, Chair. Sorry, Chair. I'd like to expound on this point regarding these documents used by ALTA.
Yes.
Because I was the one who actually picked that up.
Yes.
The rules of the Commission, Chair, Rule 11.3, says the following. No person may disseminate or use documents of the Commission without the Chairperson's permission. And after we sent correspondence inquiring as to how it is that ALTA came to be in possession of the Commission's documents to the extent that they were able to use them, we accept, Chair, that these documents are public documents. We can pick them up on the website. However, if somebody were to then discover them in a discovery bundle, it would imply, in our view, that this has been done with your consent. And after the response was not forthcoming, as to say, can you guys give us a confirmation as to whether these documents were indeed documents provided by the Commission, we then assumed that ALTA would not break the law and use the Commission's documents without the permission of the Chair. And this is now the apprehension that arises from Ms. Myeni to say, if this Commission then participated in the process of her being declared a delinquent director, it then creates this apprehension to say then that this Commission is participating in other processes outside the law. I'm not to say outside the law, but ALTA is not a law enforcement agency. That's the first point. Now, it presents you, Chairperson, with a bad dilemma to say, if you now say today you're not aware that these documents were used in this sense, but the correspondence is there to the Commission, this means then people in the Commission may not have declared to the Chair that there has been such an inquiry. Well, and that's the essence of why Ms. Myeni now has this issue with regards to answering questions as well with regards to this particular point on SAA. And just to expound on another point, Chair, the judgment of the Pretoria High Court with regards to Ms. Myeni and the delinquency application is a very open-ended judgment, and it's all-encompassing on all things SAA, because the referral to the NPA for investigation and prosecution says this matter is referred and all things ancillary thereto one can assume. So our advice then to Ms. Myeni is the following, is that look, we are holistically exposed on all points, and she, being a layperson, is none the wiser as to whether, one, she can ascertain what is self-incriminating and what isn't bar factual questions, like the first question you had, were you chair, what date were you appointed? But anything that goes to a secondary and tertiary level beyond that, we cannot keep raising our hands and saying, don't answer that, don't answer that, don't answer that, because we don't know what the scope of what the NPA investigation is right now. And then to take the point slightly further, Chair, we've then said, look, you'll have to answer other questions as they come. But we forewarned the Chair that what is likely to happen from this point forward, we're going to invoke the right not to self-incriminate by virtue of the fact that there are current media reports as recent as the Sunday saying that she is to be arrested. Now, we'd be failing in our duties not to warn our client to say, well, rather you say nothing. And we don't want to be contemptuous of the commission, but we don't even know what she's being investigated for. It could be issues around Bosasa, it could be issues around Mhlatuza, it could be a whole lot of issues. So, for the protection of our client, Chair, and not to be defiant of you, we've just said, let's limit to what we say in as much as we can. But we are here to participate, but we have this cloud and sword hanging over our necks.
Yeah. I have already said what I've said about documents that have been at a public hearing being public documents, as I understand the position. The regulations have got a particular provision, and the Commissions Act has a provision that says the proceedings of the Commission happen in a public hearing. So that's what we understand to render all documents that have been placed before a public hearing to become public documents as soon as they've been the subject of a public hearing. But before that, it's a different situation. So on the face of it, if outer obtained documents that had already been the subject of a public hearing that might not have needed my consent, but if it was before that, they may have needed my consent. I certainly have no recollection of giving any consent about that, but I don't know whether they obtained documents after they'd been used in a public hearing or before. But to the extent that it may be necessary, it might be important to just get the facts of what happened in regard to that. Yes, Ms. Hofmeyr.
Thank you, Chair. It is going to be important just to traverse a bit of law, because what's happened thus far in the engagement with Ms. Myeni and her legal team is different rights are being allied with each other. And it's very important that we understand the difference between them because, Chair, as you indicated this morning, certain rights are applicable in these proceedings, but others are not. So let me begin with the right to remain silent. The right to remain silent is a right that accused persons have under section 35(3)(h) of the Constitution. Now, that is a right, and it reads as follows, that gives every accused person a right to a fair trial, which includes the right to be presumed innocent, to remain silent, and not to testify during the proceedings. And that means the proceedings in respect of which they are an accused. So that is the ambit application of the right to silence. The right to silence, as a consequence, does not apply in these proceedings. What does apply in these proceedings is a privilege against self-incrimination, and I'll explain briefly how that becomes applicable in these proceedings. But I do just want to give you, Chair, the reference to the case which makes it clear that the right is confined to the criminal trial and does not give a basis for a person to be exempted from answering a question in other proceedings. There are numerous cases on that, but the one I draw the Chair's attention to is Thatcher versus the Minister of Justice, a 2005 4 SA 543C at paragraphs 93 and 94.
The paragraphs?
93 and 94, Chair.
Yes.
So, importantly, the right to silence does not have an application here. I highlighted a moment ago that there is a privilege that applies in these proceedings, and so let me move to that. Section 3(4) of the Commissions Act says in essence, and of relevance for this argument, that the law relating to privilege, as applicable at a criminal trial, shall apply to a person summoned before this commission, any commission, and this commission today. Now, that is a privilege that you find in Section 203 of the Criminal Procedure Act, and it's a privilege that applies to a witness in criminal proceedings who shall not be compelled to answer any question that may tend to expose him or her to a criminal charge. What's important about the test is it is focused on the answering of a question that may tend to expose the person to a criminal charge. Now, our courts have, in a number of judgments, fleshed out what the test is that should be applied when such a privilege is invoked. So just to summarize again, that is a privilege that any witness who comes before this commission is entitled to invoke, because the Commissions Act specifically gives recognition to that privilege. Now, when it is invoked, there's a particular test for its invocation. And the key judgment there, Chair, is the judgment of Mahmoud versus Janse Ferensberg and others. And the citation there is 1993, 1 SA 777A. And the appellate division there sets out the principles from page 819 of the judgment. And Chair, I submit that there are 4 important principles about that privilege. The first is that it is a personal right to refuse to disclose admissible evidence in terms of which a witness may refuse to answer a question where the question may tend to expose them to criminal charge. The second important point is that the privilege must be claimed by the witness, and the court, or the commission as the case may be, is then required to rule when it is invoked. And then the test is set for how the discretion is exercised by the body in respect of whose proceeding it is invoked. And the principle is as follows: before allowing the claim, the body must be satisfied from the circumstances of the case and the nature of the evidence the witness is called upon to give, that there is a reasonable ground to apprehend danger to the witness from being compelled to answer. Again, Chair, because it's going to be the key test I submit for today's proceedings, the question that must be answered is whether, because of the circumstances of the case and the nature of the evidence that the witness is called on to give, the question will be, is there a reasonable ground to apprehend danger to the witness from being compelled? And I'm going to digress for a moment from Mahmoud to 2 other cases because they further fleshed out how that test is applied. The first is the case of S versus Carnison, and that is a judgment of 1962, 3 SA 437T, and the relevant passages are at 439H. So in an effort to flesh out, well, what does it mean that it reasonably tends to apprehend a danger, right? The court there says it must be real and appreciable, and not imaginary and unsubstantial. So that's the first bit of further guidance. And then the second bit of further guidance is that a mere remote or naked possibility of legal peril will be insufficient. And that is the English case of R.V. Boys, 1981, 1 BNS 331. So, Chair, it is our submission that Ms. Myeni certainly has been granted a privilege, as any witness who appears before this commission is granted, to, in respect of specific questions that there is a reasonable basis for apprehending would tend to incriminate her, to then decline to answer. It's not capable of application to topics. And that's the difficulty with, in our submission, the way that Ms. Myeni proposes to approach the questioning, because as I understand her request to you, Chair, it is that the topic of SAA is such that she will not answer questions. That cannot be so on the application of the law. Each question must be carefully evaluated for its tendency to incriminate her. And where that tendency has a reasonable basis, a ruling will be made by you, Chair, with respect. And if there is that necessary tendency, not a remote possibility, but a reasonable tendency, then the privilege will be entitled to be claimed, and no answer will be compelled thereafter. So, Chair, we submit against those principles. The way we propose proceeding today is each question will be put to Ms. Myeni. And if she, in response to a question, invokes the right or her privilege against self-incrimination, an assessment will then have to be made. The question that Ms. Myeni responded to raise this issue was a question that asked her whether she recalled having made an undertaking to the Department of Public Enterprises when she was appointed as acting chairperson in December 2012. Chair, you will make a call in each case on whether that is the type of question reasonably likely to tend to incriminate her by her answer, and on each occasion, a judgment will have to be made. Chair, I would then just like to deal with the facts in relation to this suggestion that there's been some improper receipt of documents from the Commission. Chair, we've requested the correspondence to be made available to us. I have a recollection of it, so I must just make it clear. I'm going on memory now. This did occur just around the time of the outer trial, which was at the end of 2019. But what one must recall is a great deal of South African Airways evidence was led in the June of that year, before this commission. We certainly did receive a letter. It was a letter that expressed concern. There were documents that seemed to be, that had been disclosed in discovery, I think it was at that stage, that bore the watermark of the Commission, and there was concern about how those documents had been obtained. And our response was twofold, as I recall it. You see, the watermark is placed on the documents when they are placed on the website of the Commission. And so the fact of the watermark, in a sense, is a key indicator that's already public, right? We don't watermark all the pages for our investigative purposes. But we also said, but please identify the specific documents. Send us back the specific documents, because we would like to assess if there are any that don't, to our knowledge, fall within that category. And I have no record of a response to that request. We will go back through our records, and if my learned friends have an indication that there was a response to our request that greater identification of the documents be provided so we could take the matter further, they certainly can present that correspondence to us. But over the break, I'll make sure I get copies so that they are available if this point is going to be pressed at all. But a final submission, if I may. Even if, unbeknownst certainly to me, Chair, and it appears to you, somehow documents got from the Commission to in the outer trial, that is not a basis to invoke the privilege against self-incrimination. The law says there's a very particular test that must be applied, and we submit to you, Chair, that's the test that should govern today's proceedings.
Yes, from what you say, it seems you're saying by the time Outer asked for documents, the hearing relating to SAA had taken place some time before that.
Indeed.
So a lot of those documents would have been public documents by then.
Indeed, and as I understand it, the issue that was raised by Ms. Myeni's lawyers was we seeing documents with the watermark of the Commission. Explain how this can be possible. And of course, the watermark is there when the documents become public and the evidence had been laid. And then we asked, just to be cautious, please identify the specific documents that you're concerned about. And my knowledge is there was no response to that.
Okay, all right. I don't know whether it will be Mr. Masugu or Mr. Buthelezi. Or you want to stand there? Yeah, okay. You want to feel comfortable.
Mr. Masuku, we'll just sanitize. Okay, we do that every time.
Somebody must just sanitize. Well, Mr. Masugu, I must just say this to you. When I was still in private practice, one of the courts I used to appear in was called the Industrial Court. And it was permissible for lawyers to address the presiding officer seated. But I used to want to stand because I felt I presented my argument much better standing.
Yes, that's true, Deputy Justice.
Yeah.
But the chairs are a bit low and I'm feeling a little strained, so I need to stretch a little bit.
Yes, no, that's
why
fine.
I prefer
that's
to.
Fine.
Deputy Justice, I'm not going to rehash the law.
Yes.
It's not a helpful premise from which to deal with the matter as I see it. The first issue is the Commission has to be fair to Ms. Myeni. The Commission is aware in the judgment issued by Justice Tolman that all the issues that resulted in her, in her being declared a delinquent director, on all those issues, the court directed the NPA to gather all the evidence in that case, and thereafter decide whether to criminally charge her. So, before you is a witness who has an axe hanging overhead. And part of what makes a good witness in a fact-finding commission is just the freedom to speak freely, or rather the freedom to speak freely. Well, yeah, that's what I mean.
Well, the freedom to speak freely must be a very good freedom.
Yes,
Strong
yes.
freedom.
So it's the ability to speak freely on issues that the commission is looking for information on. She's not speaking freely because there is a court order directing that she be investigated and charged criminally. What she has done is to tell the commission that this is the situation she's found herself in. She calls it a dilemma. She says, I want to assist the commission reach the truth. But I face a dilemma because on one hand, I may have facts that are relevant for what the commission is looking for. On the other hand, giving that information to the commission exposes me to criminal, or exposes me to the disadvantage that in a criminal case, I may well have to face the possibility that I may not exercise my right to silence or my right not to incriminate myself fully. So she's not saying that she's not going to answer questions. If Ms. Hofmeyer wants to ask questions on SAA, she must do so. If her answer is, I invoke my right not to incriminate myself, for fear that given the judgment of Tolman, in future I may be criminalized, that should be it may well be that the answer is what is the answer as I suggest. But then where are we going with it? Because part of what this commission has to do is to look at a witness and say, is it fair? Have we created a fair environment for this witness to speak freely about matters that pertain to the commission. And so we're not suggesting that there's a blanket right to refuse to answer questions. And I don't believe that's what she's saying. She's given her an answer that will determine how she moves forward with questions that she may be asked on SAA. In other words, if the next question is going to be an undertaking, if that undertaking, I've no idea what the undertaking is referring to, but if the question about an undertaking may well set her up for a question that may result in a charge that undertaking was breached and that breach was a criminal offense, then of course she's entitled to.
It might be an undertaking to do, to perform her duties as a director to the best of her abilities.
Yes, that's fair enough. So we don't know what the undertaking is.
I also don't know.
But I do think that you have a witness whom you must accord the dignity that you have accorded all the witnesses. And part of that dignity, part of that dignity is that you are made aware that there is this X hanging over her head. And I understand that this commission may well have descended into a cross-examination environment. But we have to appreciate the importance of what she's just told you about the fact that there is a real fear based on a real judgment of a real judge that the real NPA will prosecute, will in the future charge her with crime arising from her activities as a chairperson. So if you really want to find the truth of this, have that in your mind as you ask her questions on SAA. If she affords you the answers, fair enough. But she has a right to invoke her right to privilege. I mean, the privilege to against self-incrimination. She has that right, limited as it is.
Yes.
Let's be aware that we do not place her in a position of unfairness.
Yeah.
Because these proceedings do result in a great deal of prejudice to witnesses who are otherwise assisting the commission.
Well, what I can tell you, Mr. Masuku, is that certainly from my side, and I think the same would be said with regard to Ms. Hofmeyr, I don't think there is any intention to be unfair to her or anybody. You know, certainly the idea is always to treat witnesses with fairness. But of course, one has got to strike a balance. Being fair doesn't mean that you won't be firm if you need to be firm.
No.
And of course, it does mean that sometimes when you think you are fair, the witness might think you're unfair, somebody else might think you're unfair. That's fine also, you know, but the commitment to try and be fair to all witnesses is there, and the attempt to try and make it a reality is always going to be there. And but as I say, there may be cases where I think I'm being fair and the witness thinks differently. Somebody in your team thinks differently. That's normal. That's fine. But there would be certainly an intention to carefully look at areas where her privilege not to incriminate herself should be correctly invoked and should be respected. There will be other cases where she might think it applies and maybe I think differently. But certainly the attempt is going to always be to strike a balance, bearing in mind what the test is between respecting her rights and making sure that as far as possible, the work of the commission continues without her rights being infringed.
Yes, and all I want to end by saying, Chief Justice, thank you for the assurance that you have always treated my witnesses fairly. But what I do emphasize is the fact that on the issues that she has flagged as issues that are as I said, there probably are hawks waiting outside this building to arrest her.
Yes.
That's what we heard in the morning.
Yes.
So there is a real fear with the witness when she's being asked to answer questions on these topics. And at the back of your mind, as you exercise your discretion as to whether or not to grant the privilege of that, defer to her, because this story is not going to end today. It's not going to end with the commission. We know the story will go to the criminal courts, where she will be able to speak a bit more freely because she now has to defend herself. So what I'm asking the commission to do is to defer to her a bit more, in the sense that even as you strike that balance, understand that there is a real hammer over her head, which hammer is that judgment of Toby, and real reports about real police officers looking for her in order for her to be arrested for these things. So let's not create a difficult thing for
No.
the witness.
I don't know about the defer part to her.
No. All I mean,
That might
Chief
be-
Justice, all I mean, Deputy Chief Justice, is
Take
that
into account her.
yeah, take into account that.
Her real
And in the
concerns.
exercise of discretion,
Yes.
afford her the benefit of
Yeah.
that right and say to yourself, well, look, I mean, there is in fact a real danger that she's going to a criminal case involving these very issues we're dealing with. Perhaps that's the forum where she should be dealing with them. Ms. Hoffmeyer can ask as many questions you want about the SAA. If the answer is, look, you want me to answer questions that I'm going to, that the answers that may be used in future against me in a criminal case. That danger is real. It's not just real, it's possibly imminent from what we've read in the papers.
Yes.
So we would that's all really we're asking you to do, to just strike the balance, but understand what she has told you is the basis and the premise from which she's answering questions on SAA and any other matter that may well be a matter of interest to the commission.
Yes.
So I'm not debating the law with Ms.
law,
Hoffmeyer.
yes,
I think
yes,
she
no.
can
No,
she can do
I
that.
appreciate that. Thank you.
Oh,
Mr.
and the last thing, Chair, on the issue of documents that have been used by the commission,
Yes.
I think that issue will be resolved
Yes.
when all the documentation that
Yes.
that involves communicating with the private entity and how the how outer ended up having the documents is going to be. It's not helpful to try and argue the case right now.
Yeah. No, that's fine.
In any event, Mr. Buthelezi may well address that tomorrow or the day after tomorrow if the matter proceeds that far.
Okay, no, that's fine.
Thank you,
That's
Chair.
fine. Ms. Hoffmeyer, I see we are at 9 minutes past 1, but I think you should respond if you wish to respond before maybe we take the lunch break.
Thank you, Chair. Just two brief points in response, if I may. The first is just to also emphasize that Regulation 8.2 of the regulations of this Commission also provided double protection, in a sense, to witnesses, because what it makes clear, it actually took me some time to work out how the privilege in the Act operates together with Regulation 8.2. Because what Regulation 8.2 says is any answer that you give in evidence in this commission is not admissible in a later criminal trial except for a trial related to perjury, right? I'm paraphrasing, but that's the essence of it. And it wasn't entirely clear to me how that lives alongside a privilege to invoke whenever you want and not answer.
Yes.
And what I resolved is likely to be the way to read those together is the witness who's aware of the privilege invokes it and is entitled to invoke it in the appropriate circumstances when the test is applied. But there will be occasions where a question might not be anticipated as being incriminating, or a witness might come before you not aware of that privilege. And it's in those circumstances that there's even an additional protection, that nothing that can be said here is admissible as evidence in a criminal trial, except for in relation to the crime of perjury. So, Chair, that's just an additional protection that the Commission works with in order to make its determination. And then the final point I wanted to make is just to refer, as I think your chair has already this morning, to your previous ruling when this issue was raised with Mr. Mokesi. You see there, Chair, as I understand your ruling, it was directly in line with the legal authorities that I've addressed you on. It required the privilege to be invoked in relation to specific questions, and the proceedings were conducted on that basis. And there is also an importance of parity of treatment across witnesses in this commission. And so that, I submit, Chair, would be another consideration that you'd bear in mind in making your determination whenever the privilege is invoked here. Thank you, Chair. Those are our submissions.
Yes, no, that's fine. We are going to proceed after lunch. I know that there was a time when Mr. Masuku was still addressing me when Ms. Myeni was not appearing on the screen. So I don't know whether she nevertheless was able to hear Mr. Masuku as he was addressing me, even though she was not appearing on the screen, or whether she could not hear. Ms. Myeni, were you able to hear when you were not appearing on the screen? It looks like she can't hear me. No, she can't hear me. So I think there's something wrong with the... Can you hear me now, Ms. Myeni? She's speaking, but we can't hear her.
Ms. Myeni, I think you may have muted yourself. If you just, yes,
Did you
there you
mute
go.
yourself?
I can hear you, Chairperson, very well. I was hearing you all along.
Oh, and did you hear your counsel when he was addressing me, Mr. Masuku?
I did.
Oh, okay, all right.
I did, Chairperson. Thank you.
Okay, all right. As I understand the position, based on Mr. Masuku's address and Ms. Hofmeyer's address, the position is that, Ms. Myeni, you will be asked questions even on SAA, okay? And in terms of your responses, there may be questions where you might revoke your privilege not to incriminate yourself, and therefore say that you would like not to respond to that question or answer that question. But the expectation, certainly from my side, is that there would be other questions which you ought to have no problem with, or in respect of which I would not expect the privilege not to incriminate yourself to be invoked. But from your side, you will exercise your rights as you understand them in regard to the questions that you wish to invoke it. If Ms. Hofmeyer submits that that's not a question where you can invoke that privilege, I may hear argument and make a ruling whether your privilege may be invoked in regard to that question or not. And if I make a ruling in regard to a particular question that you must answer, that would be the ruling. There may be others where I say, no, you are entitled not to answer, and then we will see as we go along. But from your side, you will protect yourself as you wish, and your legal team is here. At any stage, they will also indicate to me if they have something to say. You understand that? Do you understand that, Ms. Myeni? That delay is long. I think she doesn't hear me sometimes. Ms. Myeni?
Yeah,
Did you
yes,
understand what I said?
I can hear you very well now. Yes, Chairperson, thank you. I understood
Yes, okay.
what the chair was saying, and thank you very much. We may proceed.
Yes, okay, all right. We are going to take the lunch break now. It's about 1:15. We will resume at 2:15. We adjourn.